Hello everyone. In this presentation, the definition of the term state as provided under Article 12 of the Constitution will be explained. The preamble to the Constitution of India declares that the people of India have solemnly resolved to constitute India into a sovereign democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, and equality of status and opportunity. The fundamental rights are a necessary consequence of this declaration. The fundamental rights in India guarantee certain basic civil rights and freedoms to all and also provides a few safeguards to minorities, prohibiting discrimination and protecting religious freedom and cultural rights. Articles 12 to 35 of the Constitution pertain to fundamental rights of the people. The fundamental rights in the Indian Constitution have been grouped under 7 heads: right to equality, comprising Articles 14 to 18, right to freedom, comprising Articles 19 to 22, right against exploitation, contained in Articles 23 and 24, right to freedom of religion, guaranteed by Articles 25 to 28, cultural and educational rights guaranteed by Articles 29 and 30, right to property secured to some extent by Articles 30A, 31A, 31B, and 31C, right to constitutional remedies secured by Articles 32 to 35. As the fundamental rights constitute a limitation on the government, the most important problem which the court faces while interpreting these rights is to strike a proper balance between individual liberty and social control. Against whom can these fundamental rights be claimed? Most of the fundamental rights are claimed against the state and its instrumentalities and not against private bodies. Therefore, the definition of state becomes necessary and Article 12 defines state. According to Article 12, the term state includes the government and parliament of India, the government and the legislature of a state, all local authorities, and other authorities within the territory of India or under the control of the central government. Now, what constitutes a local authority? A local authority is an authority having separate legal existence as a corporate body. It is an independent entity and not a mere government agency. It functions in a defined area and is ordinarily wholly or partly elected by the inhabitants of the area directly or indirectly. It enjoys a certain degree of autonomy, either complete or partial, and is entrusted by statute with such governmental functions and duties as are usually entrusted to municipal bodies, like those connected with providing amenities to the inhabitants of the locality, such as health and education, water and sewerage, town planning and development of roads and markets, transportation, social welfare services, etc. Finally, such a body has the power to raise funds for performing its activities and fulfilling its objective by levying taxes, rates, charges, or fees. The actions of any of the bodies comprised within the term state, as defined in Article 12, can be challenged before the courts under Article 13(2) on the ground of violating fundamental rights. The most significant expression used in Article 12 is other authorities. The expression is not defined in the Constitution, and therefore the Supreme Court, as an apex court, had to define the term. The wider the meaning attributed to the term, wider will be the coverage of the fundamental rights. That is, more and more bodies can be brought within the discipline of fundamental rights. Now, what are these other authorities? Some high courts held that since the expression other authorities is used after mentioning a few of them, like the government and parliament of India, the government and the legislature of each of the states and local authorities, it would be reasonable to construe this expression justem generis with government or legislature. So construed, It could only mean authorities exercising governmental or sovereign powers and functions. On this interpretation, expression other authorities would only include such bodies as are functioning for or on behalf of the central or state governments. This restricted interpretation of the expression other authorities was rejected by the Supreme Court. In order to apply the ejusdem generis rule, there must be distinct genus or category running through these bodies already named. In Article 12, there is no common genus running through these named bodies, nor could these bodies be placed in one single category on any rational basis. Laying down these prepositions in Electricity Board Rajasthan versus Mohanlal, the Supreme Court held that other authorities would include all authorities created by the Constitution or statute on whom powers are conferred by law. The statutory authority need not be engaged in performing government or sovereign functions. The court noted that in the instant case, the Rajasthan State Electricity Board had power to give directions, the disobedience of which could be punished as an offense. In the next important case on the subject, Sukhdev Singh versus Bhagat Ram, the question was whether statutory corporations like Oil and Natural Gas Commission, Industrial Finance Corporation, and Life Insurance Corporation, created by statutes, came within the definition of the state under Article 12. The Supreme Court held that the statutory corporations are agencies or instrumentalities of the state for carrying on trade or business which otherwise would have been carried out by the state departmentally. Therefore, it has to be seen whether the body is acting as an agent or an instrumentality of the state. Based on whether there is sovereign power to pass laws or regulations having the force of law, extent of state control or amount of financial support, and the kind of function the body is performing, that is, whether it is performing an important public service, the corporation can be classified as a state agency. In R.D. Shetty versus International Airport Authority, the Supreme Court held that factors relevant for determining whether a body is an instrumentality or agency of the state are 1. Whether the financial assistance of the state is so much as to meet almost the entire expenditure of the corporation, 2. Whether the corporation enjoys monopoly status which is state conferred or state protected, 3. Whether there is deep and pervasive state control, 4. Whether the functions of the corporation are of public importance and closely related to government functions, or whether a government department is transferred to corporation. If, on a consideration of these relevant factors, it is found that the corporation is an instrumentality or agency of government, it would be an authority and therefore state within the meaning of Article 12. Following this approach, it was held that International Airport Authority, constituted under the International Airport Authority Act 1971, was an authority and therefore state within the meaning of Article 12. This line of approach to the meaning of other authorities has been confirmed in Som Prakash Rekhi versus Union of India and Ajay Hasia versus Khalid Mujib. In Som Prakash, the Supreme Court reached the conclusion that there is enough material to hold that Bharat Petroleum Corporation, registered as a company under the Companies Act, is state within the enlarged meaning of Article 12. Although registered under the Companies Act as a company, the Bharat Petroleum Corporation is clearly a creature of a statute, a limb of the government, an agency of the state, and is recognized and clothed with the rights and duties by the statute. In Ajay Hasia, the question arose whether Regional Engineering College Srinagar, established, administered, and managed by a society registered under the Jammu and Kashmir Registration of Societies Act, was a state within the meaning of Article 12. The court laid down the following tests for determining whether a body is a state or not for the purpose of Article 12. which is almost the same as enumerated in R.D. Shetty's case, which are whether the entire share capital of the corporation is held by the government, the financial assistance of the state is so much as to meet almost entire expenditure of the corporation enjoys monopoly status which is state conferred or state protected, there is deep and pervasive state control, the functions of the corporation are of public importance and closely related to government functions, or a government department is transferred to corporation. The inquiry must be not how the juristic person is born, but why it has been brought into existence. Whether the corporation is created by a statute or under a statute like the Companies Act or the Societies Registration Act is immaterial. The concept of instrumentality or agency of the government is not limited to a corporation created by a statute but is equally applicable to company or society considering the relevant factors as explained in International Airport Authority case. Applying this criterion, it was held that the society registered under the Jammu and Kashmir Registration of Societies Act was an instrumentality or agency of the state and the central governments for the reason that these governments had full control of the working of the society and the society was merely their projection. Following the law laid down in Ajay Hasia case, various authorities like the Indian Statistical Institute, the Indian Council of Agricultural Research, Sainik School Society, UP State Cooperative Land Development Bank Limited, Children's Aid Society Bombay, all societies registered under Societies Registration Act, Project and Equipment Corporation of India Limited, a Government of India undertaking, Food Corporation of India, a statutory corporation, the Steel Authority of India Limited, a public limited company owned, controlled, and supervised by the central government, the Indian Oil Corporation, a company registered under the Companies Act, a state aided school whose employees enjoy statutory protection and which is subject to regulations made by the State Education Department, a medical college run by municipal corporation, several state electricity boards created on the lines of Rajasthan Electricity Board, Central Inland Water Transport Corporation Limited, a government company jointly owned by central government and two state governments, a government company constituted as Development Authority under State Town Planning Act, Reserve Bank of India, nationalized banks, regional rural banks established under the Regional Rural Banks Act, Port Trusts created under the Major Port Trusts Act, Central Institute of Buddhist Studies, Delhi Transport Corporation, Indian Tourism Development Corporation, State Trading Corporation, State Financial Corporation, Air India, the Central Board of Secondary Education, and the Sabrimala Temple, a public temple, have been held other authorities within the meaning of Article 12. In Chandramohan Khanna versus NCERT, the Supreme Court held that NCERT, being largely an autonomous body, does not fall within the definition of state under Article 12. The court observed that Article 12 should not be stretched so as to bring in every autonomous body which has some nexus with the government within the sweep of the expression state. A wide enlargement of the meaning of state must be tempered by a wise limitation. It must not be lost sight of that in the modern concept of welfare state, independent agency, institution, and corporation are generally subjected to state control. Generally subject to state control. In MC Mehta versus Union of India, without deciding the question finally, in a unanimous opinion of the Supreme Court, Chief Justice Bhagavati advanced strong arguments for including even the non-government companies within the meaning of state, if for reasons of state control and regulation and the kind of public function they are performing, they satisfy the test of being an instrumentality or agency of the government. Again, an expansive interpretation of the expression other authorities in Article 12 is furnished by the decision of the Supreme Court in Pradeep Kumar Biswas versus Indian Institute of Chemical Biology. In this case, the Supreme Court held that the Council of Scientific and Industrial Research is an authority under Article 12 and was bound by Article 14. The court held that the control of the government in CSIR is ubiquitous, that is, everywhere. The court laid down the following proposition for identifying of authorities within Article 12. The question in each case would be whether, in the light of cumulative facts as established, the body is financially, functionally, and administratively dominated by or under the control of government. Such control must be particular to the body in question and must be pervasive. If this is found, then the body is a state within Article 12. On the other hand, when the control is merely regulatory, whether under statute or otherwise, it would not serve to make the body a state. Now, what is state for the purpose of Article 12 need not be state for other purposes. For the purpose of wider application of the fundamental rights, state has to be defined liberally but not for other purposes. Thus, an employee of the public corporation may challenge the violation of his fundamental rights by the corporation. But for that reason, he does not become a state employee and he cannot seek the protection under Article 311. The words "under the control of Government of India" in the section are meant to bring into the definition of the state not only every authority within the territory of India but also those functioning outside, provided such authorities are under the control of the Government of India. Thus, relief under Article 32 of the Constitution can be given to the petitioner in respect of an executive or administrative order of an authority under the control of Government of India but functioning outside the territory of India. In such cases, suitable orders may be passed against the Government of India, directing them to give effect to the decision of the court in exercise of the power of control over the authority outside the territory of India. A judicial authority or a quasi-judicial authority is not subject to the control of government in the functional sense, and so no order can be passed against the government for enforcement of a fundamental right by such a body functioning outside India. The mere fact that the authority is appointed and is subject to the disciplinary action by the government does not determine the question of control. What is necessary is a control of the functions of the authority. The government should be in a position to give directions to the authority to function in a particular manner with respect to such function. If you look at Article 12, you will find that judiciary, though an organ of the state like the executive and legislature, is not specifically mentioned in Article 12. Now, does it mean that the judiciary is not meant to be included in the concept of the state? The answer would depend on the distinction between the judicial and the non-judicial functions performed by the court. While performing judicial functions, the judiciary cannot and should not be equated with other organs of the state, that is, the executive and the legislature. While acting on judicial side, the courts are not included in the definition of state. A fundamental right is not infringed by judicial order, and no action therefore lies against a court or judge on the ground of breach of fundamental right. The reason being that what a judicial decision purports to do is to decide the controversy between the parties brought before the court. Whether the findings of fact recorded by the judge are right or wrong, and whether the conclusion of law drawn by him suffers from any infirmity can be considered and decided if the party aggrieved by the decision of the judge takes the matter before the appellate court. In exercise of non-judicial functions, the court falls within the definition of state. It has been held that when a court, in exercise of its statutory rule-making powers, makes rules which contravene the fundamental rights of the citizens, the rules could be held ultra vires and appropriate remedy under Article 32 or Article 226 could be given. Similarly, when they deal with their employees or act in any other matters purely in administrative capacity, the court may fall within the definition of state for attracting writ jurisdiction against their administrative actions only. Even a quasi-judicial body does not infringe the fundamental right merely by misinterpreting a law. But if a quasi-judicial body acts under an ultra-vires law or outside its jurisdiction or ignores mandatory rules of procedure prescribed in the relevant law, or infringes principles of natural justice and thereby affects a fundamental right, then its action can be quashed by the courts. This, in brief, is about the definition of state under Article 12 for the purpose of fundamental rights under Part 3 of the Constitution. Thank you.